If someone asked you if you ever partied with Donald Trump in the presence of underage girls, you're gonna say no. But you are not Jeffrey Epstein, who was asked that exact same question and answered this.
Though I'd like to answer that question, at least today, I'm going to have to assert my 5th, 6th, and 14th Amendment rights, sir.
He'd like to answer that question. Well, I don't exactly know what that means, but I do know why people plead the 5th during depositions. So today we're going to unpack what it actually means to invoke the 5th, 6th, and 14th Amendments during a civil proceeding, why this clip is going viral, and what you can and cannot conclude from this very disturbing video. Now, I'm not going to belabor the point about who Jeffrey Epstein is. I'm sure you already know if you're watching this video. But here is a quick recap that we need to know to understand everything about this clip. Jeffrey Epstein was a wealthy financier and sex offender who had ties to several prominent politicians and celebrities. Epstein's estate was valued at over $550 million at the time of his death. And in 2007, Epstein faced federal charges for sexually abusing dozens of underage girls. But instead of prosecuting him in federal court, U.S. Attorney Alex Acosta approved a secret non-prosecution agreement that allowed Epstein to plead guilty in state court to 2 lesser charges: solicitation of prostitution and solicitation from a minor. Under this deal, Epstein served just 13 months in county jail, and federal prosecutors agreed not to charge him or any of his co-conspirators. And that sweetheart plea deal is the subject of Ghislaine Maxwell's current appeal to the Supreme Court. Now, this deal was kept secret from his victims, which arguably violated federal law, and one court said Epstein's victims, quote, suffered unspeakable horror at Epstein's hands, only to be left in the dark, and so it seems affirmatively misled by government lawyers. In 2017, President Donald Trump appointed Acosta as his Secretary of Labor. Acosta's role in the Epstein case went largely unnoticed until the FBI arrested Epstein for sex trafficking. The backlash forced Acosta to resign in 2019. And a few months later, Epstein died by suicide while he was in jail. Though by that point, Epstein's victims had sought justice for many years. In the 2010s, dozens of women sued Epstein for sexually abusing and trafficking them when they were minors. And the lawsuits alleged that Epstein lured them with promises of money, modeling opportunities, or help with education, only to coerce them into giving massages that quickly turned sexual. Some women said they were abused repeatedly over months or years, and that Epstein trafficked them to other powerful men. And accusers say Epstein continued to run his sex ring out of the U.S. Virgin Islands, where he owned property. The Attorney General for the U.S. Virgin Islands described it as, quote, the perfect hideaway and haven for trafficking young women and underage girls for sexual servitude, child abuse, and sexual assault. And separately, the U.S. Virgin Islands also filed a lawsuit seeking $190 million in penalties and disgorgement from JPMorgan Chase, alleging it benefited financially from Epstein's sex trafficking operation and failed to report suspicious financial activity. Now, the first publicly recorded lawsuits against Epstein were in 2008, when Jane Does sued him in Virginia and Florida. In 2010, Epstein settled a spate of lawsuits from victims who alleged he abused them in Florida when they were underage. And in 2014, more Jane Does came forward. They alleged Epstein ran a sex abuse ring and lent underage girls to, quote, prominent American politicians, powerful business executives, foreign presidents, a well-known prime minister, and other world leaders. And the lawsuit identified Prince Andrew and lawyer Alan Dershowitz as Epstein alleged clients. Then in 2019, 3 women sued Epstein in New York. 2 of the plaintiffs were young aspiring dancers. Epstein lured them to his orbit by promising to introduce them to prominent people in the dance industry, and they alleged that he assaulted them repeatedly during massages. Another woman said Epstein promised to pay for her medical care, only to coerce her into providing sexually explicit photographs of her while he was actually in the work release program. And after Epstein's death, more than 150 women sought settlements, according to records of payouts by his estate to the Jeffrey Epstein Victims Compensation Fund, which is set up in the Virgin Islands. The estate has paid out over $121 million to these victims between 2020 and 2021, and 92% of the claimants accepted offers from the estate, but as a condition of settlement, their names and allegations remain anonymous. So the actual number of victims and settlements is likely much higher. Many of Epstein's civil cases were settled quietly with non-disclosure agreements before his 2019 arrest, and one of the most high-profile cases was brought by Virginia Giuffre, who accused Epstein and his longtime associate, Ghislaine Maxwell, of recruiting her as a teenager and forcing her to have sex with Epstein and his powerful friends, including allegedly Britain's Prince Andrew. Now, in 2010, the prince famously flew to New York City to meet with Epstein shortly after Epstein got out of jail. And in 2021, Giuffre sued Andrew for battery and intentional infliction of emotional distress. Giuffre died in April of 2025, and her death was ruled a suicide. However, Giuffre's case, along with others, helped expose the scope of Epstein's abuse and was a driving force behind the release of sealed court documents, including flight logs and depositions. Now, a deposition is part of the discovery process where one party is allowed to depose one or more witnesses under oath. Basically, the attorney is questioning that witness and they're under oath as if they were testifying in court. And historically, those depositions have been recorded using a stenographer who takes contemporaneous notes. But in addition to that, in modern day, usually in a large enough case, you're going to videotape those depositions as well. But what's important here is that in the relevant depositions in the discovery proceedings of these cases, Epstein was deposed and invoked his Fifth Amendment rights thousands of times. And that brings us to the moment, a 2010 deposition where Epstein is under oath, being questioned about his connections to Donald Trump. So as you might have seen earlier this week, the channel Midas Touch resurfaced a clip from a 2010 deposition where Epstein is being grilled by a lawyer for one of his victims. Now, it's not clear which lawsuit this deposition resulted from, but the New York Times first reported on the video back in 2019. But as we talked about, around this time period, there were a ton of lawsuits against Epstein. So if you have discovery from any of these lawsuits, let me know. But this clip starts with a relatively benign question that Epstein does choose to answer.
Have you ever had a personal relationship with Donald Trump?
What do you mean by personal relationships?
Have you socialized with him?
Yes, sir.
Yes?
Yes, sir.
So at this point, Epstein does not invoke his Fifth Amendment rights, but then he's asked this question.
Have you ever socialized with Donald Trump in the presence of females under the age of 18?
Though I'd like to answer that question, at least today, I'm going to have to assert my Fifth, Sixth, and 14th Amendment rights, sir.
So what Epstein did there is known as pleading the Fifth Amendment. This is a legal maneuver that allows a person to refuse to answer questions in legal proceeding if the answers could potentially expose them to criminal or other prosecution. Now, rightly or wrongly, pleading the Fifth is frequently misunderstood by lay people to mean that a person is guilty of a crime.
The mob takes the Fifth. If you're innocent, why are you taking the Fifth Amendment?
Yes, that Donald Trump has often equated silence with guilt. He even tweeted during the Bill Cosby scandal, quote, "I'm no fan of Bill Cosby, but nevertheless, here's some free advice. If you are innocent, do not remain silent. You look guilty as hell." Of course, he changed his tune when he was being criminally prosecuted, and he personally took the Fifth hundreds and hundreds of times. But the right against self-incrimination isn't about optics, it's about constitutional protections. And in criminal proceedings, juries are not allowed to assume that silence equals guilt. So why did Epstein suddenly clam up when asked about Trump? Well, perhaps we can gain some insight by looking at why their friendship ended. In 2019, after Epstein's very public arrest, Trump claimed that he was not a fan of Epstein and ceased all contact with him about 15 years ago when a Florida real estate deal went sour. Trump repeated this story while distancing himself from Epstein's criminal behavior, all the while denying rumors that Epstein was banned from Mar-a-Lago for sexually harassing a teenage daughter of a club member. But a few days ago, Trump changed his story. Yes, Epstein was banned from Mar-a-Lago, but according to Trump, this was because he was trying to poach the staff.
Other people would come and complain, this guy is taking people from the spa. I didn't know that. And then when I heard about it, I told him, I said, listen, we don't want you taking our people, whether it was spa or not spa. I don't want him taking people.
And according to Trump, he definitely, positively never ever visited Epstein's island. It was, quote, "One of my very good moments, I turned it down, I didn't want to go to his island." And one way to investigate whether these claims have any validity is to examine headlines across the political spectrum and examine the history of factual accuracy, as you'd often miss important details and facts if you only get your news from a few sources. And Trump's revised history with Epstein was covered by 211 outlets, with 23% of the coverage coming from the left, 62% coming from the center, and only 15% coming from the right. And from the left, sources were most likely to frame Trump's statements as quasi-admissions of guilt, focusing heavily on the phrase, "I never had the privilege to visit the island." Center outlets provide factual, straightforward retelling without emotive or partisan language. And on the right, headlines typically frame Trump's statements as an explanation or revelation and go on to argue that they should be considered credible. Now, headlines and coverage vary greatly depending on the source, which is why I love today's sponsor, Ground News. The Nobel Peace Center called Ground News an excellent way to stay informed, avoid echo chambers, and expand your worldview. And I couldn't agree more. They've been a longtime supporter of this channel and independent journalism at large. So please consider checking them out. Ground News gathers related articles from around the world and across the political spectrum so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. And I also love their blind spot feature, which shows you stories that are unreported by either side of the political spectrum. And with a topic like Jeffrey Epstein, there's plenty of blind spots to be discovered. And that's precisely where you'll find the story we just talked about, as it was unreported by both the left and right-leaning media. But all this is why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. The subscription gives you unlimited access to every feature, including the bias insight tool and blind spot feed. But even though the details about Trump and Epstein's relationship are muddy at best, it would be incorrect to assume that this is what motivated Epstein to plead the Fifth. To understand why, we need to break down the constitutional rights that he invoked and what they actually mean in the legal setting. But let's talk about the Fifth Amendment and why it's a cornerstone of our justice system. Now, the privilege against self-incrimination has its roots in 17th century England, where Puritans often refused to cooperate with religious interrogations. Many were pressured or tortured into confessing their faith, while others were presumed guilty simply for staying silent. Now, English law didn't formally recognize a right against self-incrimination until much later. But when the Puritans fled to America to escape religious persecution, they brought this principle with them. The Founding Fathers later enshrined it in the Fifth Amendment to the U.S. Constitution as part of the Bill of Rights. And over time, American courts have expanded this protection to cover situations where a person's words could be used against them in a criminal case. And the relevant text says, quote, "No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law." And you've definitely heard this right articulated in Miranda warnings on TV and in movies.
You have the right to remain silent. If you give up the right to remain silent, anything you say can and will be held against you in a court of law.
And that's because in a criminal case, the Fifth Amendment gives a defendant the right to remain silent and refuse to testify. No one can force a defendant to testify against their will. However, if a defendant chooses to testify, they typically waive their Fifth Amendment privilege for the remainder of that trial. That means they can't selectively answer some questions while refusing to answer others. And when someone pleads the Fifth in a criminal setting, prosecutors may not comment on a defendant's refusal to testify as evidence of guilt because it would unfairly punish someone for simply exercising their constitutional right under the First Amendment. And one of the core purposes of the Fifth Amendment is to protect innocent people who would be caught up in criminal proceedings through no fault of their own. That's why the privilege against self-incrimination extends not just to defendants, but to any witness in a criminal trial. And unlike defendants, witnesses can assert the Fifth Amendment selectively. They can choose to answer some questions and invoke the Fifth on others, depending on whether a particular question might incriminate them. And unlike criminal defendants, witnesses can be legally compelled to appear and testify. But the eagle-eyed among you might have noticed that this was not a criminal proceeding. This was a civil trial. Now, Fifth Amendment protections aren't limited to criminal trials, but they're also not the same in civil trials. In civil lawsuits like the one against Epstein, a witness can invoke the Fifth if their testimony would expose them to criminal liability in a future criminal proceeding. But this right is not absolute. In civil actions, the judge or jury can draw an adverse inference to support liability when the defendant invokes the Fifth Amendment. So in a civil setting, if someone takes the Fifth and refuses to answer, you can assume that the answer would be pretty bad for them. However, the adverse inference can only amplify other evidence. The Supreme Court has ruled that a person cannot lose a case if the only evidence is that person's silence. But invoking your Fifth Amendment rights in a civil deposition is not necessarily a signal that you're guilty. It could be a way to avoid giving answers that could be twisted or used later in a criminal trial, or that you just don't want to answer. And lawyers often advise clients to invoke the Fifth because even truthful answers can be risky when a parallel criminal investigation is in play. The Bill Cosby prosecution illustrates the complicated strategic dynamics between civil and criminal cases. In that case, more than 24 women accused Cosby of assault. And in 2005, Cosby gave a deposition in a civil sexual assault case brought by Andrea Constand. He answered the questions about drugging women and his sexual conduct only after a public assurance from the district attorney that he would not be criminally prosecuted. Cosby relied on that promise and waived his Fifth Amendment rights. So during his deposition, Cosby admitted drugging women with Quaaludes in order to have sex with them. Now that answer clearly incriminated him in criminal conduct. And over a decade later, a new prosecutor used that very testimony to charge and convict Cosby in a criminal trial. But in 2021, the Pennsylvania Supreme Court overturned that conviction, ruling that prosecutors violated Cosby's Fifth Amendment rights. The court had held that Cosby had relied on the government's non-prosecution promise when testifying, and using that testimony against him later was a clear violation of due process and the Constitution. Now, while the legal failures in the Cosby and Epstein cases were different, they both show how missteps in handling immunity and testimony can derail justice. Cosby's conviction was overturned because prosecutors violated an earlier promise not to criminally prosecute him, which induced him to waive his Fifth Amendment rights in a civil case. And in Epstein's case, the issue wasn't a Fifth Amendment violation, but rather a secret non-prosecution deal that protected him and his associates while denying victims their legal rights. But an additional complication is that all these rules only apply to the courts themselves. You, as a layperson viewing this testimony, can come to whatever conclusions you want to. As long as you're not a member of a jury, you can see someone invoke the Fifth and come to the conclusion that it's an admission of guilt. Especially in a context like this, where Epstein answered the question, does he know Donald Trump, but refused to answer the question, did he engage in any kind of incriminating activity with Donald Trump? But that being said, whatever conclusion you come to, you should understand that sometimes invoking the Fifth has nothing to do with being guilty or not. And there are a ton of reasons why you might take the Fifth that have nothing to do with being guilty of any crime at all. But additionally, Epstein also cited the 6th and 14th Amendments as well. And here's why. The 6th Amendment guarantees rights specifically related to criminal trials. These include the right to a speedy and public trial, the right to legal counsel, and the right to confront witnesses. While these protections are essential once a criminal case moves into the courtroom, they don't generally apply to a civil deposition, which is what Epstein was involved in here. Still, some lawyers have their clients invoke the 6th Amendment during depositions out of caution, especially if they believe criminal charges could follow. Especially where there are Doe plaintiffs where they might not actually know the identity of the plaintiffs. And originally the amendments only limited the federal government, but the 14th Amendment, which was ratified after the Civil War, includes a due process clause that requires the states to honor most of the rights in the Bill of Rights, including the 5th Amendment and parts of the 6th Amendment. So when a defendant is in state court or in a proceeding involving state action, they often invoke the 5th Amendment and the 14th Amendment at the same time. So in Epstein's case, invoking the 5th and 14th Amendments made sense legally. Citing the 6th Amendment probably wasn't strictly necessary. It may have been just a way to signal that he believed the questioning could lead to unfair treatment or criminal exposure. In practice, though, the 5th Amendment was the one that was doing the heavy lifting. But there's one more interesting detail about pleading the 5th. Now, contrary to how it's often portrayed in movies or TV, the law does not allow a person to simply say, I plead the 5th one time and then remain silent for the rest of the proceeding. Instead, the privilege has to be asserted in response to each specific question that could potentially elicit incriminating information. This legal rule ensures that the court can evaluate whether the 5th Amendment truly applies to each individual inquiry. In fact, Epstein once pleaded the 5th over 1,200 times in a 2010 deposition. Epstein frustrated the plaintiff's lawyers by refusing to answer even the most basic questions like identifying a window in his mansion. When the lawyer asked him, quote, "And in this photograph, do you see a room depicted in the back?" Epstein replied, "5th." The lawyer asked him to clarify the quote, "You're taking the 5th about what is shown in this photograph." Epstein then said, quote, "I can't see anything, I'm sorry." The frustrated lawyer reiterated his question, quote, "Do you see a window depicted in this photograph?" And Epstein said, "I don't know what it is, I'm sorry." And as frustrating as this is for the lawyers, Epstein had a right to refuse to answer all the questions, though at the risk of imperiling the judgment in the civil case. But the high number is due to the legal rules requiring the witness to assert the 5th in response to each individual question rather than issuing a blanket refusal. And by the way, we don't know if this deposition excerpt is the same 2010 deposition in which he was questioned about Trump. But I would not be surprised if the whole deposition eventually surfaces. And President Trump is no stranger to this tactic as well. In August of 2022, he appeared for a court-ordered deposition as part of New York Attorney General Letitia James's civil investigation into the Trump Organization. Trump invoked his 5th Amendment right against self-incrimination more than 440 times, answering only one question, his name. Though he did get that question right. And we know how that case turned out. After a months-long trial in 2024, Justice Arthur Engoron found Trump and his entities liable for fraud under New York law. He ordered them to disgorge over $364 million in ill-gotten gains plus interest, though the case is on appeal. But all this is a good reminder that if you have a legal issue, whether it's a criminal matter or a personal injury, you really need a great lawyer. And for more, here's my partner at the Eagle Team Law Firm. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could. But what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle Team.